week that you were grading papers, and you want to try and be consistent.
Right.
Although sometimes the first paper sometimes gets a very high grade, sometimes gets a very low grade. Then you go back and say, wait a second, maybe I didn't do right by the first paper.
Right, right.
And
also the combination of civil procedure and torts is really useful because the way that it's taught is usually in a vacuum, or that's how I learned torts didn't really focus on any of the litigation issues, and that's what struck me about this book as well, that this could be used by a layperson who either had been in, had a personal injury and wanted to know what lay ahead if they decided to press suit and follow up, or anyone who just might be in this situation where they need some more background information. It's not just students.
That is true, because it does fill in all the gaps.
Right.
You know, why is my case going here? Why are we having a motion? What are we doing? That answers all those questions. And law students need to know that as well.
Right.
They get mixed up in not knowing the various stages. Plus in law school, you know, you only can take so many courses at once. Civil procedure sometimes is taught in the first term, sometimes it's not taught in the first term, and when it is taught, they teach a lot of things that are really important to know, but which are not geared towards handling tort cases or contract cases. They spend a lot of time on jurisdiction, long-arm jurisdiction, issues of whether the court's power, federal courts versus state courts, all of which are really, really important, but are not the kinds of things that lawyers with ordinary cases and ordinary courts spend a lot of time with.
Right.
And then I found that the students like cartoons, so we have cartoons in the book to help explain the cases, and those were done by a wonderful cartoonist, and we'd work together. I'd tell him what I wanted, and sometimes he'd give it to me, sometimes he wouldn't, so I send it back. There's one cartoon that a fellow is hunting, and he's apparently killed by a bull in a corral, and so the cartoon came back and the bull was fabulous, but I couldn't find the dead guy. So I kept looking. I said, you got to make him bigger.
Right.
So he said, okay. So you see his boots sticking out from under the fence, bigger, so you had to worry about accuracy. And then another case where a fellow who's very drunk is given a roast beef sandwich and immediately chokes to death, and so he sues the diner. And so have to have the roast beef sandwich exactly right. And so the idea is to make it so that the cases are memorable in order to memorize and understand the legal procedures and rules that come out of these cases.
Right. I think I've looked at many case law books, but this is the first that I've seen with pictures, and it is helpful because there are people who learn through visuals, and it helps. It's a memorizing technique, and
well, some of the tort case books have pictures of the judges. Boring, and I mean these guys in robes and wigs and things. And I don't think that's very helpful. Although you look at Judge Cardozo and walking down the steps of the courthouse, and you know that he's a real person.
Right. Exactly.
But I think the illustrate the cases are better.
Right, and I think that. What you're saying, the editing process for the images has not just been with the cartoons, but this entire book really started back in 2007, and you talk in the intro about how you've been getting feedback from students and incorporating the feedback from the students.
Hundreds and hundreds of students have used these materials in various forms, and we'd always ask them to comment on them, and we get dozens of comments, and a lot of comments are in the back of the book. Students find it very useful. They appreciate that because it's a guidebook.
Right.
It really does help you navigate this first term of law school for them and for anybody else who navigates what goes on in a courtroom.
Right, and even if you've taken torts and you are preparing for the bar or any other class, I think this is really helpful.
That's a good reminder, because again, a question like, does the plaintiff have a cause of action against the defendant for this injury? That's code.
Right.
I mean, first you have to know what the plaintiff is, you have to know the defendant, you have to know the meaning of a cause of action, you have to know a standard for a cause of action, you have to know what a prima facie case is, you have to know what a theory of the case is. So we're constantly speaking in code as lawyers, and I guess that's the way we keep clients away from us, and why we can charge fees, but it's not very helpful to somebody who is trying to understand what's going on.
Right, and this decodes the language of law for torts and makes it accessible for especially 1L students who don't have really any contact coming into a torts class or any other of their law classes.
Right.
So, yeah.
We have, here at New York Law School, I use this in the evening division where you have a lot of students who are working, some of them in law firms, and they're among the most enthusiastic about it because their law firms don't teach them enough.
Right.
And so they're very happy that they're paralegals or secretaries or assistants doing something, or they're police or something like that. So New York Law School attracts a lot of people for whom this clarifies things.
Right, and even from working in a firm, you might not still pick up on some of the more technical meanings. Right. So even students.
It's all technical. Law is technical.
Right.
And it requires mental acuity, and it requires methodology. And if you don't learn it, you can't do it.
Right. And it's nice to have something like this book, which breaks down to the most fundamental level, really the exact words, and makes it so that students can use those words and answer exams in a way that makes you happy to read them. So,
but more than exams, it's so that you understand the language when you're listening to lawyers talk, or when you're listening to any field. If you take Music 101, you can learn what a concerto is, and you don't have to be a musician. The same with the Jumpstart Torts. You really can understand your local newspapers when they tell of an injury and tell of a lawsuit that's going to happen and the tree fell. And this puts it in layman's language, which was the language that I was interpreting for Ross, and how we really, every time, make it more clear for the person who has no legal background.
Right.
And first-year law students generally have no legal background.
That's right.
They are, come in with no knowledge, and all of a sudden they're thrown into this, and that's what this was designed to help.
Right, and I think that's part of why this could even be valuable to not a layperson, not a student, not anybody with more background than just watching Law and Order on occasion. It really is accessible.
Law and Order is pretty good.
Oh yeah, I do. I do like Law and Order. So.
Although it's pretty hard to do an entire criminal case in an hour. I mean, generally it takes months and months.
Months, right. They make it seem so simple and easy, but so does this book, really, because I wanted to also talk about the Iraq format, and that you break that down here. It was amazing. I didn't get an Iraq format till halfway through 1L. It would have been so...
May I interrupt? You're saying a word that somebody might think is in the Middle East.
Right, that's true. Right. So,
and they haven't got the code.
Right.
So I think you should explain first.
So I is the issue. When you get a fact pattern, you're going to be expected to issue spot. And the next letter is R, and that's for the rule. And A is analysis, and L is...
No, C is
conclusion.
C is
conclusion. So to wrap up, you want to wrap it all up before you move on to the next issue. And usually a student struggles with 15 or 20 issues in a fact pattern.
I like formulas. I like to have a formula, not because formulas give you an automatic answer, but because it gives you a starting point.
Right.
So the IRAC formulation is only one way to think about law, but it's one, and it's a formula. So it's a way of outlining. So there's you learn about the 5 or 7 paragraph essay. This is the same sort of thing, that it gives you a way of organizing an answer, a beginner to organize an answer, and then to do something that lawyers will understand and in the order in which they need to understand it. That's what it does. So IRAC is a formula. It is not it's not a computer that spits out an answer. All it is a way to organize an answer, but it's extremely important and very helpful to students, because the students, they have scrambled facts and they have scrambled arguments, and they don't quite know where to begin and which piece do you do first, and that's what that's about. Right. So that's what this book does too. And so here's where you start.